So the U.S. Supreme Court, with its 6-3 conservative majority, continues to issue decisions which are extremely unfavorable toward federal administrative agencies. Not super surprising that these decisions turn out to be 6-3. Last week, we talked about the overturning of Chevron deference. It struck down 40 years of precedent. This time, we're going to talk about what I think is a less important decision, a less impactful one, but still one which is very relevant in the case of securities regulation, and that is Securities Exchange Commission versus Jarkesy. So this involved the Seventh Amendment, and the Supreme Court handles these cases. And one of the things you'll learn from reading these types of cases is that so many constitutional law issues really do arise when we talk about administrative agencies. Sometimes they're warranted, sometimes they're not warranted, and it seems like it's just a frivolous challenge. But here's one that I think really illustrates the difference between some of the mindsets that we have among our justices, the competing views on formalism versus functionalism, strict adherence to constitutional text versus concern for public policy and effective government efficiency. And I think that's really well illustrated in the majority opinion by Chief Justice Roberts, contrasted with the concurring opinion of Justice Gorsuch, and the dissent written by Justice Sotomayor that Justice Kagan and Justice Jackson unsurprisingly joined. So the holding of SEC versus Jarkesy ended up being that when the Securities Exchange Commission seeks civil penalties against a defendant for securities fraud, the Seventh Amendment commands a jury trial rather than agency fact-finding. So the defendant needs to be subject to trial by jury. The agency cannot adjudicate the claim itself. And basically, it's really unsurprising that Chief Justice Roberts wrote this opinion. He decided it on fairly narrow grounds, which is such typical Roberts. I mean, we see this a lot with him where he says, well, there are a lot of questions that come up in this case, and I am only going to address this one question and not these other questions. So George Jarkesy was the defendant, and he actually won in the Fifth Circuit, which is not super surprising because the Fifth Circuit is pretty much the most conservative federal circuit. And the Fifth Circuit not only said that the SEC's trials that they had adjudicated by themselves violated the Seventh Amendment, but that they also violated the non-delegation doctrine as well as the removal process. And both of those are constitutional issues dealing with Article 1 and Article 2. And so when this gets to the U.S. Supreme Court, Chief Justice Roberts says, those are issues, but we're not going to address those issues. We're going to address this on the Seventh Amendment alone because the Seventh Amendment can resolve this case. It's that straightforward. So Chief Justice Roberts writes about kind of the history of the SEC, how it kind of arose during the Great Depression. The SEC obviously enforces the Securities Exchange Act. And basically, they have two ways of bringing an enforcement action, two forums where they can adjudicate the enforcement actions. So they can adjudicate the matter themselves, also known as in-house, where they can either delegate a member of the commission or an administrative law judge to handle the case and do the fact-finding, or the commission itself can do it. The commission is able to review the fact-finding and the findings overall of the ALJ or the commission member that does it, but they're not obligated to do so. So there's not that much accountability for them. Or the SEC can bring it to a federal court. And in the context of a federal court, you do have a jury hear the case, and obviously in that case, it's perfectly consistent with the Seventh Amendment. So after the Dodd-Frank Act of 2010 passed, we know that was a Great Recession piece of legislation intended to help things. And obviously there's some evidence to show that it actually did, but a lot of people took issue with some provisions of it. And one of the provisions of it was that the SEC actually can seek civil penalties not only in federal court, but in its own in-house proceedings. So originally the SEC could actually just seek civil penalties in the context of a federal court. So yeah, 14 years ago, they acquired the ability to seek civil penalties in their own in-house proceedings. And they decided to do that against George Jarkesy. They did this in 2013, and Jarkesy and his counsel are arguing that this is inconsistent with the Seventh Amendment. It entitles him to a jury trial. So basically, Chief Justice Roberts notes all this stuff about how judicial review is deferential toward the agency, and the agency can even admit evidence that's hearsay or that would normally be inadmissible in federal court. So the agency really has a crud ton of power in running these trials. It seems like Chief Justice Roberts, in his telling of the story, is considering that a lot and considering how he doesn't really think that the agency should have this much power. So George Jarkesy ended up having a final order levied against him of $300,000 in penalties. And Chief Justice Roberts handles this by first pointing out this case does implicate the Seventh Amendment. He says that the SEC's anti-fraud provisions replicate common law fraud, and it is well established that common law claims need to be heard by a jury. The Seventh Amendment, basically, he says, provides this. It's that straightforward. So having decided that it implicates the Seventh Amendment, he does address to the public rights exception. And so he writes that it's been held that the public rights exception allows Congress to assign certain matters to agencies for adjudication, even though such proceedings would not afford the right to a jury trial. And Chief Justice Roberts ends up saying that this doesn't apply because the case doesn't fall within any of the distinctive areas involving governmental prerogatives where the Supreme Court has concluded that a matter may be resolved outside of an Article III court without a jury. So, and one of the points he makes is that the public rights exception is confusing. It's not really that easy to apply. The dissent ends up kind of disagreeing with him on that. But yeah, and again, he says, yeah, the Seventh Amendment can handle this all on its own. He says money damages are the prototypical common law remedy. What the SEC is seeking here is money damages that are designed to punish and deter conduct. They're not compensatory, so they're basically a remedy at common law. Again, another issue here, a Seventh Amendment case, is this Atlas Roofing Company case that both the majority and the dissent talk about a lot. One thing that they disagree on is whether it's applicable. Chief Justice Roberts doesn't believe that it's applicable, that it held that Congress could assign the Occupational Safety and Health Act adjudications to an agency because the claims were unknown to common law. And here he argues that the claims were known to common law, so Atlas Roofing Co. does not control here. Now, the dissent obviously ends up strongly disagreeing with this. The concurrence written by Justice Gorsuch is joined by Justice Thomas, so basically two of the most conservative members of the court. I'm surprised Alito didn't join this. And they basically write, yeah, this is a really easy case. We really agree with the majority, but we think they should have gone further. They think that the majority should have brought up some of the other constitutional issues, that the Seventh Amendment does not exist to protect judicial authority for its own sake, that it exists to protect the individuals. So yeah, this is a really originalist concurring opinion, one that's really pro-individual rights. They admit that George Jarkesy is probably an unsympathetic guy, but we really need to protect individual rights here. And they also say that the SEC still has plenty of power and recourse after this decision, which is interesting. So they're sort of sounding like they kind of agree with the idea of the SEC being powerful and having recourse, that they're not saying they support small government or low power for administrative agencies, but they're saying they're trying to trim away at basically too much power. And then the dissent written by Justice Sotomayor is joined by Justices Jackson and Kagan. They argue that this upended longstanding precedent, and they repeatedly tout the case of Atlas Roofing Co. And just like the majority, they actually believe that this is a really straightforward case, but for different reasons. The majority argues it's straightforward because of the Seventh Amendment. The dissent argues that it's straightforward because Atlas Roofing Co., when applied to this case, produces an easy result. They say it's permissible for Congress to assign a non-jury fact finder to adjudicate this dispute. They say the public rights doctrine really isn't all that confusing. And yeah, Atlas Roofing Co. basically shines light on this case and reveals it to be a really straightforward one. And on public policy grounds, they blast Chief Justice Roberts' majority opinion, saying it is a, quote, devastating blow to the manner in which our government functions. So this is something that's pretty typical of what we call a functionalist opinion. They're attacking the idea of being rigidly formalistic. They think that this is something that's really convenient for Congress. It's really helpful. It benefits the American people. Administrative agencies should have this power. Congress creates them. Congress's will and Congress's intent should be respected. So they're really taking on this strongly deferential perspective, strongly deferential to Congress. And Chief Justice Roberts, on the other hand, is saying, no, I think we should focus on these constitutional provisions. So yeah, this will be a really interesting case to look at going forward and how it affects the SEC. I expect that a lot of students, law students who are in administrative law, will have to read this case going forward. I also recommend reading all the opinions if you are interested in how the Supreme Court works, how the different justices view administrative law and constitutional law. They're not too long, really. Chief Justice Roberts goes into quite a bit of history that I didn't talk about here, which is pretty typical of him and typical of conservative justices. But yeah, it's really interesting stuff. And I anticipate that next year we'll continue to see more decisions that undermine the power of administrative agencies to use their discretion. So let me know what you think in the comments. Do you agree with the majority? Do you agree with the dissent? Maybe the concurrence? Do you think that this was a good decision? Do you think that the Seventh Amendment doesn't apply here? I really want to know because public policy is such an interesting thing to discuss. I'm very much a political science geek and an administrative law geek. So yeah, let me know your views, and I look forward to seeing you next video. Thank you.